We're going to get started. So good morning, everyone. I'm Gary Feldman, and together with Tamsin Kaplan and Larry Casey, we'll be presenting what I'm told is our fifth morning breakfast on developments in employment law. So it's nice to see familiar faces. It's nice to see some new faces. We're going to cover several topics that are current and of interest to businesses, people who have employees. As we usually do, small group, we like to make this as interactive as possible, so don't feel like you have to wait. You know, we'll take questions as they come up during the individual topics, so don't feel like you have to wait till the end. So I hope you enjoy. I hope you all learn something. I hope you all get to take at least several things away from here into your business practices. And we'll start. I think Tamsin's going to lead us off.
Good morning, everybody. I'm delighted that you've all come to join us for breakfast and to learn a little bit more about employment law this morning. You know, Larry and Gary and I get to do this stuff every day, and I know you're going to be super jealous when we're done because it's very interesting. So first we're going to talk about documentation and progressive discipline. And what I want to focus on for this portion of the presentation is smart performance management. I mean, with employees, obviously you get the good, you get the bad, and you get all kinds of everything in between. And our focus as managers and supervisors and business owners and HR professionals is, of course, to support the success of our people. And if we treat them well, they will treat us well. We want people to come to work every day and feel motivated and feel that they are invested in what they're doing. So how do we make sure that we are getting the best from our employees, making them feel positive about what they're doing, and at the same time protecting ourselves should there be problems, should there be a need for discipline, should there ultimately have to be a termination? Because I'm a lawyer, I'll tell you, a lot of times legal claims result from termination of employment, even from discipline and other adverse actions that you may take over the lifetime of an employment relationship. So smart performance management. Obviously, complete, accurate job descriptions, very important. Frequent open communication, very important, communication. And what could be more simple, but it's actually very challenging because when those tough conversations arise, they're hard, and a lot of us want to avoid them. We're conflict averse. We want to just, you know, put our head in the sand and hope it gets better. But if people don't know that there's a problem or don't know what your expectations are, how can we expect them to meet those expectations and to improve? Regular written performance appraisals are very important. I encourage you all to at least do them annually, and then in addition when there are specific problems. And of course, documentation is absolutely key. Now, why is documentation essential? Number one, it supports what I was just talking about in that it is the foundation for communication, good relationships, mutual discussion of expectations, how to improve, how to invest in the success of the employment relationship. But it's also the documentation that is going to be the foundation of a good defense should there be a legal claim. Many times I get calls from my clients who are employers, and they say, this person is horrendous. They're never on time. They're rude to our clients. We got to get rid of them. We have to terminate them today, if not sooner. And I say, okay, let's slow down a little bit. Can you send me their personnel records? And what do I get? Oftentimes I get a practically empty folder. Right, guys? Right? Okay. Because although this is the most horrendous employee, we've never gone to the trouble of communicating with them and documenting that communication. Or we've communicated with them, but we've never gotten it into the record. And what do I want to see when you tell me this employee has serious problems, ongoing problems, incurable problems? I want to see documentation of this. Because
what's even worse, I would say, to getting a personnel record that has nothing in it is getting a personnel record that includes reviews that are really very good. Because it's hard for people in a one-on-one. It's hard for many managers to sit across the table and criticize an employee. So we get the call, Tamsin gets the call, this person's terrible, we look at the file, oh, he got meets expectations or exceeds expectations, and
then you got a problem. Very good point, yeah. So we have positive performance information or we have no performance information. And then should there be a legal claim because the person feels that they've been treated unfairly, they've been discriminated against, harassed, or retaliated against, they feel that there's some kind of breach of contract when they're terminated, they come back to you and we want to be able to show that you had a legitimate business-based reason to terminate this person. You want to have that track record. Many times, a syndrome that I see is, okay, we've either, as Gary said, positively reviewed this person and it was a mistake, or we've not put anything in the record and it was a mistake, and now we're ready to terminate them. And so you've heard this, let's create a paper trail. Okay, so at the very last minute, you give the person a performance improvement plan. And the performance improvement plan is a plan that would be impossible for them to meet within whatever the time period that's set. And you don't actually meet with them or support them or help them meet the goals of the performance improvement plan. It's all a big sham. And that's a big mistake too, because of course the documentation up to that time doesn't support it. And then your conduct in doing this performance improvement plan undermines any kind of argument that you might make that you were actually trying to constructively communicate, invest in success, support this person, help this person. So I am a big, big supporter of documentation, communication. It will help you should there be a legal problem. It will show that the decisions are not arbitrary, that these things have occurred over time and that you've invested and worked with this person. Obviously, it's important that they're accurate. As Gary said, make sure what's in the file is accurate. And of course, it preserves history because memories fade. Before we get to progressive discipline, I just want to remind you that should there be a successful claim for discrimination, harassment, or retaliation under the Fair Employment Practices Act in Massachusetts, under the Americans with Disabilities Act, under any of those acts, actually, what's going to happen is there's going to be a suit in the MCAD, a claim in the MCAD, the Mass Commission Against Discrimination, and or the Equal Employment Opportunity Commission, which is a federal agency, and then that can proceed to court. The plaintiff's lawyer, the lawyer for that employee, is going to be looking for this documentation. They're also going to be looking for depositions, meaning that you will have to, as a decision maker, an HR professional, or a supervisor, give your testimony under oath during the process of litigation. And so things can get very difficult. And the easier you make your job and our jobs to defend the case in advance by working with somebody and communicating and documenting it, the easier your life will be and the faster you'll be able to dispatch with that potential big problem and nip it in the bud. Hopefully you can avoid it happening, the legal claim happening again, at all. Now, in Massachusetts, we do have individual liability under our Fair Employment Practices Act. So it's very important that you and your supervisors and managers and HR people understand that not only is the company potentially liable, but also you as an individual, if you are the supervisor, manager, if you've been accused of somehow being involved, aiding and abetting the discrimination or harassment, or being responsible for retaliation, or in any way interfering with the person's opportunity to pursue their rights under the law, that you personally can be liable. So that means you or your managers' personal houses, cars, kids' college education. So this is serious stuff, and it's not just the company that could potentially be on the hook. So why progressive discipline? Progressive discipline is fair. It gives people an opportunity to improve. It gives you an opportunity and sort of a framework for communication. We start with a more mild form of discipline, a conversation, a counseling, maybe an oral warning, then a written warning, then a final warning. I do not advise that you have a set in stone progressive discipline policy in your handbook. I think that's a mistake because in many situations, depending on the circumstances, depending on the personalities involved, you may not be in a position to go through each and every one of those steps. And you don't want to promise your employees that you will. progressive discipline is good because it demonstrates flexibility, good communication, support of the employee, a true commitment to improvement, to solving problems. But if you have a policy that's rigid, then you can't be flexible. You can't make decisions based on the individual circumstances. Fairness, consistency, use that policy, use progressive discipline, and it's a motivational tool, obviously. It's an opportunity to tell people, here are our expectations, and if this doesn't improve, unfortunately it could get worse. So let's work together and make sure it improves and we solve this problem now. So elements of effective progressive discipline. Again, you want to articulate the expectations of the job, the expectations for performance. Centralization. You do this through HR, you do this through whomever holds your personnel records and is responsible for personnel policies and practices, so that there's consistency, there's communication, and it's coming through a centralized person, so that you don't have different managers and different supervisors doing things in completely different ways without any guidance or communication within your organization. Progressive, again, it starts with a more mild form of discipline and progresses to a more serious form of discipline. Now, I'm talking to you and using the term discipline. I think it's important in the early stages when you're talking to your employees to be as open and forthcoming and positive and supportive and constructive as you can. But behind the scenes in our centralized personnel office, HR office, this is actually the beginning of building a record should we need it. Commitment to improvement. So many times I don't see this. We need a genuine commitment to improving this employee's performance, to working with them to make sure that, again, they're a happy, productive worker and they're meeting the needs of our business. Acknowledgement. What I mean by acknowledgement is that we want to make sure that there's a dialogue, that there is communication, and that it's documented in the file that the employee has received this information. Do they have to agree with the information? Do they have to agree with your assessment? Not necessarily. They always have a right, and we'll go over this later, to contest what you're saying and to put in the record what their point of view is. But we want to have acknowledgement that they have received this information. And we're going to talk about personnel records a little bit later and logistically exactly how you go about doing that. Okay, progressive discipline steps. Counseling, talking, verbal warning, having a conversation saying, if this situation doesn't improve, we're going to have to go to some kind of a write-up. And then it's an opportunity to have a conversation and talk about how we can all do better and how you can support this employee's improvement. A written warning potentially, a performance improvement plan, or what's called a corrective action plan sometimes. These are the goals that you need to meet within this time period. We will meet weekly to review your progress and try to be always in these issues, in discipline and documentation, as objective as you can, and focus on the job necessities, the job functions, the job responsibilities, not on personal issues. Keep it away from the personal and always refocus on the job description, the requirements of the job. This is all about getting the job done. And then, of course, ultimately discharge. Now, is this like a lockstep process where you have to do each of these steps? No. But these are the various pieces that you can use.
And I just want to share, Tams and I are in agreement that if you going back to that last slide, those are not lockstep provisions that you should put, that we would recommend you put in a handbook or an employee manual.
Definitely not.
You can get a lot of employee manuals out there on the internet. Sort of the canned versions will have that. We don't recommend it because you set some rules like that, and you can put all the contractual disclaimers you want in your handbook, but it'll create a set of expectations, and it could come back to bite you at the end, because sure enough, there'll be some step that you want to avoid. Now, some clients, we have some larger employers like the idea of a lockstep for purposes that the people heading HR want to know that their line managers are going to follow these steps. But for the most part, we don't recommend it. And if you have a handbook that could be read to have a lockstep progressive discipline, we would recommend you take a look at that and talk to us about that.
Totally agreed. And oftentimes when I work with my clients on their employee handbooks, my clients suggest or request that we put in what I consider to be sort of, backroom information. I call it a procedures manual that's separate from what may be in your handbook. So as Gary just said, for example, you may not want to put, and we don't recommend that you put, an inflexible specific progressive discipline plan in your handbook, but it may be that for HR procedures, policies and procedures sort of behind the scenes, that these are our expectations and this is what we want our managers to do so that everything is consistent. Yes?
Are the first two steps documented in some way?
I'm glad you asked that, and we'll talk about this more. When we talk about personnel records, we'll talk about this more, but I'm glad you asked that question. Yes, that was an oversight. I didn't mention that. Even when it's a conversation, what I always recommend is that you send just a follow-up email afterward confirming that we had this conversation and that a copy of this email is going into your personnel records. That's a very important piece. So even if it's oral, even if it's informal, I always recommend that you follow up with something that's documented. And it can be, very light touch, just an email confirming that we had this conversation, and always put on the bottom, this will be placed in your personnel records, because there are requirements under state law that people see anything that may negatively impact them.
I just had kind of a very broad question. My understanding is that employment in the state is at will. So, do you have any statistical information given X number of terminations in the state, how many actually result in litigation that actually can be pursued?
I would doubt if that particular statistic exists. But if you go to the website of the Massachusetts Commission Against Discrimination, they have annual reports that always track how many claims there are in each various area, like age discrimination, sex discrimination, race discrimination, et cetera. So that might be interesting information for you to see. I don't think anybody's tracking how many people are terminated every day or every week.
Keep in mind that what the MCAD tracks or provides in their annual report is statistically derived from complaints filed at the MCAD. There's any number of, take that as a multiplier of claims that are asserted informally by demand letters that a terminated employee hires a lawyer, a demand letter gets presented to the employer, there's a back and forth and a resolution of that, and never gets to the MCAD.
Good point. So there are a lot more claims than you're going to see recorded anywhere because they are informally resolved. I'd like to share with you a case that I often talk about, which is the Ferguson case, Ferguson versus Host International. And this was a number of years ago, but it goes exactly to this issue of not putting in your handbook a promise that everybody's entitled to certain progressive discipline steps. And in that case, this guy worked at a Dunkin' Donuts in the airport, and Dunkin' Donuts is really fast, and in the airport especially, and they had a special. It was like 2 donuts and a coffee for $1.99 in those days. Maybe it's like $4.99 now, I don't know. And someone said, "What's so special about your special?" And he said, "Nothing." And he got fired. Now, there were other reasons why this guy got fired. Obviously, there was something brewing. There were issues with his employment. But they had made the mistake of having in their employee handbook a progressive discipline policy. And even though, as Gary mentioned, there were disclaimers all over this handbook saying, depending on individual circumstances, we may or may not enforce this progressive discipline policy. This handbook is not a contract, nor is it a promise that the employer will take any of the steps. The employer reserves the right to act in its own discretion, et cetera, et cetera. It doesn't matter. The Supreme Judicial Court decided that this guy had a legitimate case, and they found in his favor that he was deprived of a contractual right to have those steps of the progressive discipline policy enforced in his situation.
So just to follow up too on that employment at will, some of you may be sitting there saying, wait, it's employment at will, why do we need to do all this? Well, the reason you're doing this and setting it up and documenting it is so that you're trying to eliminate the possibility that the employee is going to come back and say, oh, you did it for other reasons which are unlawful. I'm in a protected category, you did it because of my race, my age. If you go through these steps and you document, then you have a case in which you can say, no, here's the basis why we did. So the employee's coming in making an allegation, but there's no substance to it. So that's really, you're looking to try to avoid that and cut that off at the knees, essentially is what you're trying to do.
Right, to support the fact that this was a legitimate business decision. Right. But also, I like to stress to have a good relationship with your employee and to make it a better place to work. Okay, do the right thing, be fair, be consistent. Consistency is so important that people in the same circumstances are treated the same way. We call it similarly situated people. Treat similar situations similarly. And hence the photo, the picture there, be flexible depending on the circumstances. Don't lock yourself into any particular commitment to particular progressive discipline steps. Documentation is essential, as we've just discussed, and here's what I have to say to you. Document, document, document. Always document. And here's why. Should the employee be discharged? Should the employee be subjected to an adverse action and go to a lawyer, a mean, evil lawyer? You know how they are. The lawyer's going to say, why did you terminate my client? We want that documentation of that fair process. Every chance was given to this employee to succeed. If progressive discipline policy is in place, has it been followed? What do the documents show? Is this consistent with your past practices, the way you've treated other employees under the same circumstances? Are there any employment agreements? And if so, have you acted in accordance with those agreements? These are the questions that we'll be faced with should there be any potential legal action. Okay, now we're on to some of the exciting stuff.
Okay, I get to talk about politics in the workplace. Here we are on May 12th, 2016. Some of you may be aware we're in the midst of a presidential election this year. Certainly generated lots of discussion, a lot you can't get away from it. And I've gotten calls from employers, okay, we're in the midst of an election, a campaign, a presidential cycle. Gee, is there anything we can do? Employees have their First Amendment rights. Is there anything we can do to keep things under control in the workplace? So let's go through this a little bit. So for recent survey, I should have credited the survey company here, but at the last polling data that I saw, substantial number of your employees are going to be talking about politics in the workplace amongst themselves, with their customers, with their suppliers, with their bosses, with their management. It's a topic of interest. Almost half your employees will expect to discuss the presidential election within the workplace. And more than 20% of workers surveyed said that discussing politics in the workplace leads to heated exchanges or fights between your employees. So what's the impact for you as the employer? We'll discuss, and then we'll discuss what can you do about discussions of politics in the workplace and not run afoul of any legal obligations or legal requirements. So the issues for employers include, you got a loss of productivity. This is in an unfettered, unrestricted workplace. If you've got employees coming in every morning, following Twitter, following the news, getting into discussions, you got people on one side, people on the other side, people in the middle, you're going to have a loss of productivity. You're going to have a loss of attention and focus to what you're paying your employees to do and what your employees are there to do, which is to advance the interests of the business. And you're going to lead to workplace morale. Because if your goal is to have a collegial work environment where your employees, together with management, everyone's working side by side, you're going to have some problems there when things get heated in the workplace over political discussions. Particularly, this cycle seems to be generating more heat on all sides than in the past. And when this spills out, if this spills out into discussions in front of your businesses, your customers, clients, even suppliers, you run the risk that your customer is going to take a different view of the political discussion that your employees, your business may be putting forth, And people take these things very personally, very seriously. So you're likely to have an impact to your customer relations, which you don't want to have. So I get this question, I've gotten this question several times already in this campaign election from the people in charge of HR. Well, we've got someone who's wearing a button for this candidate or that, or someone who's got a sign, or someone who's coming in with a shirt, or talking about it in the workplace. What can we do? They have their First Amendment rights to discuss political speech. And the answer to that is, if you're a private employer, which most, if not everyone here is, the simple answer is no, they do not. There is no First Amendment right of your employees in a private work setting to discuss politics. There is no First Amendment right. First Amendment rights protect citizens against governmental action, either federal or state action. But in the context of private employment, your employees do not have First Amendment rights. So you can set, as the employer, you can set the parameters, either informally or formally through the issuance of policies. You can set the parameters and the boundaries of the kinds of discussions that your employees are permitted to engage in while in the workplace. Distinguish that, of course, from what your employees will do outside the workplace in their own private time, which you cannot step into that bound. And I'll come back to it later. Even the general rule that I just gave you about your ability to circumscribe and set the boundaries for what's discussed in the workplace has one exception, one or two exceptions that I'll get to. But that's the starting proposition. Your employees do not have First Amendment rights. And though they may come to you and say, you're infringing on my First Amendment right, you can gently tell them that as a private employer, they lose those First Amendment rights when they come into the office. Applies only to government action. Employees have no constitutional right to political expression in the workplace. And the same with political activities. Your employees do not have a right to come into work and display campaign literature, campaign slogans, T-shirts, posters, buttons. They have those rights in their private life, but when they cross the threshold of your employment, you have the right to say, we don't want to have any political discussion or any political displays here. Employees do not have a right to solicit campaign contributions while at work or using your company's equipment. No right to wear campaign shirts, buttons, etc. But if you're going to do that, what you have to do is apply these rules consistently across the board. So your action and your managers can't say, well, because he or she may not like a particular candidate, you can't tell that employee you shouldn't be, and we don't want you to discuss that candidate's views or display literature from that candidate while someone sitting somewhere else in the workplace who has a political expression that your manager agrees with is allowed to do that. So if you're going to do that, you have to do it across the board. Yes, Sean?
Now, is this on my property, or is this while clocked in? I mean, when we get to that lunch unpaid kind of game, do I have to worry about that?
No, on your property for sure, and even within your workspace. Once they come onto your premises.
Okay.
So what you can't do is what employees are doing in their private life, as long as they're not representing your company, right? So that would be if employees are using company email account from their mobile devices that has a company's signature, a company block on the bottom, you have the right to restrict them from engaging in political activities to the extent that they're representing the company at any time.
So if he goes across the street for lunch, he can put his badge on and stand out there and shout for Trump.
Right.
When he comes back, if he's eating lunch on your premises, you can say none of that on my premises.
So what are the risks to employers in this topic? So unequal enforcement, as I discussed before, this candidate you can talk about, this candidate you can't, can lead to claims of discrimination, harassment, or retaliation. And if you don't have a written ban on all forms of political activity, political campaigning, political expression in the workplace, you can have if your managers, your supervisory personnel don't observe that, the risk is that you can end up generating or having it lead to claims of discrimination. For instance, you have a manager that talks about, well, I support this candidate because he or she does not is a right to choose candidate, or he or she has a particular view about immigrants and building walls, or anything to do about immigration policy. Well, you have a employee who's working under that supervisor who then may feel that they're being harassed, or when some action is taken against them, it's because based on their religion. They may have a genuinely held religious belief that does not support abortion, or maybe a national origin, someone who is from another country who feels that this person, although in the guise of talking about a candidate, that candidate's position may implicate things that would be tied to protected characteristics such as age, religion, national origin. And so by me having those, just as having those discussions within the workplace, particularly, especially when coming from a manager or a company representative, you may be creating a hostile environment for employees who do not share those views. And then if there's any adverse action taken against those employees, you may have given the employee the ability to assert, well, that person, I'm getting terminated or I'm getting disciplined because I don't share that candidate's views on these political beliefs that touch one of my protected characteristics. Discussion of political views may lead to claims of discrimination in the workplace.
I have a question.
Yes.
So at our company, a lot of the supervisors are Facebook friends with females.
I'm sorry, I couldn't hear you.
A lot of our managers or supervisors are Facebook friends with just with their employees, their direct reports, and they might say, or they have said, I like Donald Trump, or or I like Hillary, or whoever, and I hear about it sometimes afterwards that like the direct reports don't like certain things. Can that be taken back to the office, or that's on Facebook?
Well, that raises a whole other, complicated issue about social media and the employer's right to regulate social media. What people are expressing in their private lives, such as on any form of social media, including Facebook, as long as they're not, attributing that or associating themselves with the employer, in other words, their Facebook page is truly a personal site, they have the right outside of work, I would say, and ask Larry to communicate and express their political views as however they may want. The bigger issue is, and it's not necessarily a legal issue, but you've got the issue of should supervisory managerial personnel be socializing, and Facebook and Twitter, these are all social media, so it is a socializing environment. Should they be socializing with subordinates? And there's that is just ripe for danger on many fronts, because people tend to use social media to publish things about their personal life, photos, expressions of things that they want, including politics. So when you have a supervisor who is friends with subordinates outside of the workplace on social media, it creates the possibility of creating uncomfortable relations in the workplace. So that's not necessarily a legal answer, but I would certainly encourage supervisors and managerial personnel to be careful about their outside of work social relations with subordinates. But the specific question is, as long as the personnel are not affiliating themselves with the employer in their expressions of political views in their private life, even on social media, I don't think you have any ability to regulate that.
What about putting restrictions on them doing it during the work hours while they're working?
Yes, you can do so. Certainly you can restrict employees' ability to do that during the working hours. But someone goes home at night, goes onto Facebook and starts liking this candidate, reposting this candidate said, this candidate said, it's politics, right? It's going to lead to, by its very nature, to different points of view and disputes, and then the natural input, then you have no way of barring that, those attitudes, the emotions of all that, the hard feelings then come into the workplace when you have coworkers sharing their views, sharing their social interactions. Tam?
Yeah, I just want to bring up at this point that the National Labor Relations Board has come down really hard on employers' restrictions of employee use of the internet and social media. And so I would just warn you to be very, very careful if you're limiting employee use of social media, to think very carefully about it, potentially to consult with counsel about it. Because under the National Labor Relations Act, employees have a right to what's called concerted activity, to talk about the terms and conditions of employment on social media, in emails, et cetera. It's the modern water cooler. And that is a right that people have because they have the right to discuss the terms and conditions of employment in order to potentially unionize. And so the National Labor Relations Board right now, in its current state, is interpreting this extremely broadly and making sure that employers give employees almost unfettered opportunities to use the social media for various interactions. There's a recent case in addition called Purple Communications, which says that although you can restrict employee use of your electronic communication system during work hours, you cannot restrict it during non-work hours. So we're getting into some very sensitive areas here. Certainly within what Gary's talking about, I completely agree with him about politics. But we need to be careful to give employees their rights with respect to use of social media and the internet otherwise.
So that's a great segue into one of the exceptions to the rule. So go ahead, yes?
It becomes really challenging as the work life blends a great deal. So, we have employees that have flexible schedules. It's a challenge.
It is a challenge. It's a challenge for us as lawyers to try and make some sense and get some guidance and advise future conduct based on all the pronouncements of the NLRB. Their general counsel's office issues a report. They've issued several reports collecting their cases and their views on the use of social media in the workplace and what an employer can and cannot do. You can line up a number of those cases alongside each other, and it's very hard to find a consistent rationale, a consistent fact pattern that goes throughout it. So it is a challenging area. So it's an area that if you've got questions, you should definitely be seeking legal advice on, because it's a minefield out there. And that does segue into, so I told you earlier that as your employees have no First Amendment rights in the private workplace, and you as employers are free to restrict political discussion from the workplace. I mentioned there was one or two exceptions. Well, the NLRB, under the NLRA, there is, that's one of those exceptions. So as Tamsin said, employees have what are called Section 7 rights under the National Labor Relations Act. If you've been here to any of our previous seminars, we've talked about social media and the manner in which and the extent to which the National Labor Relations Board has insinuated itself into protecting the rights of employees in a union employer, but even in a non-union employer. So all employers are subject to the restrictions of Section 7, which restricts your ability to, which gives workers the rights to communicate in what's called concerted activity over workplace issues, compensation, terms and conditions of employment. So how does that impact the discussion of your ability to regulate the extent of political discussion in the workplace? The general rule, as I told you before, still applies. No First Amendment rights. You're entitled to, you have the right to restrict political discussion from the workplace. However, in certain circumstances, since the NLRA protects employees' rights to communicate about issues relating to wages, hours, and the terms and conditions of employment, you take that concept and you lay it or overlay that onto political discussion. So the Section 7 rights will impact your ability to restrict political speech about issues relating to protected topics under the NLRA. So what would that be? Example, vote for Smith, protect our wages, or support our union, vote for Smith. Those are examples of the exception to the rule. You cannot restrict your employees' abilities to engage in, or their right to engage in concerted activity, even if that involves a discussion of campaign or candidates in an election cycle, as long as there's a connection to Section 7 rights to discuss and engage in concerted activity about wages, hours, and the terms and conditions of employment. So if an employee came in and said, with a shirt or a sign that said, "Vote for Smith," you can restrict that if you had a policy. Comes in with says, "Vote for Smith, protect our wages," you would be running afoul of Section 7 and Section 8 of the NLRA if you restricted that kind of political activity in the workplace.
Gary, what if you said, take off the vote for Smith part, but you can still wear a shirt that says protect our wages?
You certainly can.
You could, okay.
Yeah, I think that's a fundamental Section 7 right
Yeah.
for workers to do that.
But you could tell them, take off the vote for Smith part.
Well, in that connect, no. If an
You don't think
employee
so?
came in or posted a poster or came in with a banner or something that's "Vote for Smith, protect our wages," or "Support our union, vote for Smith," that would be, in my view, that would be protected.
Altogether, including the vote for Smith part.
Right.
And if two employees are talking back and forth about candidates with regard to protecting wages.
Sure. Sure. There could be, goes to the lunchroom discussion that we talked about, or any discussion in the workplace. If workers are talking about candidate so-and-so will be better for us because he or she supports a higher minimum wage, or he or she is more union friendly and will have better union rights, better organization rights to organize, run a union organizing campaign because this political candidate will support those views, that's all protected conduct. So that's an exception to the general rule. So what can and should employers do with respect to this topic, especially between now, May 12th, and the election in November? Consider implementing a written policy that prohibits, restricts political discussion and expression in the workplace using company assets on work time. Tie that restriction to conduct that harms productivity in the workplace and or impacts customer relations. Include a carve-out for the NLRA activities, which I went through on the previous slide.
And just, Gary, one point before you turn, that second bullet about tying the, can you go back one? Tying the restriction to conduct that harms productivity. If the employees are engaging in discourse about protecting wages, and I like this candidate for that, and it's harming productivity or inhibiting productivity, you can limit it to certain times or locations on the premises. You don't just have to allow employees to have this discourse, even under the NLRA, anytime they want, as long as it doesn't impact the workplace productivity and what's going on in operating your business. You may have to allow them to do it on the premises in a certain area or a certain time, but if it's impacting the work productivity, you can restrict it.
You can, excuse me, you can do that proactively, as in ahead of time say you can talk about these things at lunch or at this time, as opposed to waiting for it to happen and then.
Right. I'd say, yes, I would say, that would be a very fact-specific situation. What type of business do you have? How is it really going to impact productivity? So you'd want to really go through the analysis. If I put this restriction on, is it really fair and reasonable? And is it limited to a period of time where it's not going to impact productivity? And if they do it any other time, it would. So you want to be careful there. But yes, you can. You could designate areas where they can go and talk about these things without, if you're on a line working on cars and things are moving very fast, you don't want them having this kind of discourse. They're concentrating on their job.
So and the other interesting issue there is, because we talked about productivity in the workplace, is also the issue of impacting customer relations. So if you have employees who are in a customer-facing position, working on a counter selling parts or selling, facing customers at a sales position, and they come in wearing, with a button, "Vote for Smith, protect our wages." Smith is associated with one particular political party rather than another. Can you restrict that? Because in a customer-facing role, you may be, listen, we are politically, vis-a-vis our customers, we're politically neutral. We don't want to be seen as supporting this party over that party. So my view would be, I'd ask Larry if he has the same view, that although employees have their Section 7 rights, it's fair to give consideration to the company's, your business's relationships with your customers, and to restrict that in a customer-facing position, because you don't want to, it's your business and you don't want to alienate your customers along political lines. So employer actions, we would suggest, or strongly recommend that you train your managers as soon as you can, or get some discussion out there, get some training out there to your managers sooner rather than later, particularly as we're heading into, as things head into the general election campaign, part of the campaign. Consistent enforcement is critical. You don't want to be in a situation where you have an employee saying, well, my co-employee gets to talk about that candidate or that political issue. I'm on the other side of that issue and I'm getting shut down, I'm getting restricted in that. So if you're going to apply, if it's in your interest and you want to have a restriction on political discussion in the workplace among your employees, make it consistent as to all sides of all issues, all parties. In Massachusetts, time off for voting law, the Massachusetts statute gives employees up to 2 hours to vote after the polls open. The statute says if requested, presumably if requested in advance, although it doesn't say how much time in advance. And even though the statute that I'm quoting is related to particular manufacturing, I mean, there's a limitation on the kinds of employment, but I think it's fair to say that across the board, employers should, to be consistent with the Attorney General's guidance, provide employees time off to vote on election day. It does not have to be paid time. It can be unpaid time. But you should have a policy about that. You should have it in writing. And you should ask your employees to tell you if in advance, so you're not caught shorthanded in any particular critical function for the 2 hours after the polls open. Now on the employer side, as an employer, you are restricted in Massachusetts. There's federal election campaign laws on this, which are a little bit not quite as blanket protection, but in Massachusetts, for your Massachusetts employees, you are prohibited from attempting to influence an employee's vote or political contribution. All right, thanks. Turn it back over to Tamsin.
This is a really exciting topic. Fasten your seatbelts. You are going to love this. Okay, maintaining personnel records. This is the statute that governs personnel records, 14952C. And it defines personnel records this way: a record kept by an employer that identifies an employee to the extent that the record is used or has been used or may affect or be used relative to the employee's qualification for employment, promotion, transfer, additional compensation, or disciplinary action. My advice to you is be more broad rather than more narrow in defining what goes into your personnel records. Better to have more than less. Personnel records specifically include but are not limited to this information according to the statute: name and address, date of birth, job title, and description. Note it says job description. Rate of pay, compensation paid, payroll records, starting date, job application, resumes and inquiries prior to employment, inquiries in response to job postings or advertising. Any waivers of rights are specifically mentioned in the statute, but I would recommend that any documents that the employee signs be in their records, such as acknowledgement of an employee handbook, any restrictive covenants, non-solicitations, non-competes, confidentiality agreements, things of that nature. Obviously, all performance evaluations and all evaluation-related documents, all discipline records, including written warnings and probationary periods, everything. Documents relating to any disciplinary action. So when it says documents relating to, I read that to mean not just the discipline itself, but any potential investigation or background information. Now, you may want to put investigation material in a separate file, but ultimately, depending on how the statute is read and the individual circumstances, it may be considered to be a part of the personnel records generally. And of course, in the end, a termination notice, a dated termination notice, goes into your personnel records. What do they not include? Okay, Any information of a personal nature about another person, another employee. Many times when I'm reviewing personnel records, I do find information about other employees. Sometimes, for example, an employer will keep information and they'll have a list of various employees on a printout. So we want to be sure that we're being careful that only information about this employee goes into his or her personnel records. Employee medical information must always be kept separately. Anything regarding a workers' comp claim, disability application, request for sick time, doctor's note about accommodation, FMLA application, anything regarding their medical condition should be in a separate file. Now, I-9 information. I just recently had the opportunity to speak with an immigration lawyer at the Mass Bar Association. And I-9 information, as you know, is required from every employee in order to document that they are qualified for employment in the United States. There's a whole list of documentation that is applicable to this and that satisfies the requirements. Now, this immigration lawyer who specializes in employment immigration suggested that it's very important that you keep all the I-9 information in one place together, because should you be audited, you do not want the authorities going through your personnel records and potentially finding other violations. You want to make sure that you've got all your I-9 stuff organized in order of employment, in order of hire, and that it's all in one place so that it is separate.
So then,
Go ahead.
from that slide, is it the position that I-9 information is not within the scope of the Section 52C of the Personnel Records Statute?
I think that I-9 information needs to be maintained separately. But you're right, but I think ultimately it is part of the personnel records. And I'm glad you asked that, because one of the things that comes up oftentimes is that people think only what's in the personnel file or folder constitutes personnel records. But as you've seen, the definition of personnel records is very broad, and so it may be that what actually constitutes complete personnel records is in various places. It's in HR, it's in your supervisor's desk, it may be that a piece of it is in that I-9 binder. So I would keep that in mind when people request their personnel records, which we're going to get to next. Okay, what are employees' rights under the Personnel Records Statute? Number one, an employee, if they request it in writing, must be given access to review their personnel records within 5 business days. And that should be on the premises under your supervision. Number two, if somebody requests in writing a complete copy of their complete personnel records, you're required to provide that within 5 business days following receipt of the written request. Now, very importantly, this is something that came into the law several years ago, and I know it's been difficult for employers to integrate into their policies and practices. Notice to the employee within 10 days following placement in the record of any information that may negatively impact that employee. So let me read you this section from the statute. An employer shall notify an employee within 10 days of the employer placing in the employee's personnel record any information to the extent that the information has been used or may be used to negatively affect the employee's qualifications for employment, promotion, transfer, additional compensation, or the possibility that the employee will be subject to disciplinary action. Very, very broad. So when we say may negatively impact the employee, I recommend to you that pretty much anything that is not glowingly positive must be in there. And if you're going to put in the negative stuff, you really should be putting in the positive stuff. But with respect to the 10-day notice, within 10 days of placing that in the employment record and in the personnel records, the employee must be notified and given an opportunity to see whatever that is that's going into their record. So the easiest way to do this, as I recommended earlier, if there's not a written warning or something in writing, is to communicate by email. We had this conversation about your persistent tardiness. I'm hopeful based on our conversation that this issue will be resolved, and I look forward to continuing to work with you. a copy of this email will be placed in your personnel records. Now you've met this requirement. The documentation of that conversation that may negatively impact the employee is in the personnel records, and the employee has been notified that it's in the employee record, in the employee's record, and not only have they been given an opportunity to see it, they've been given a copy of exactly what's going in. And I think for employers, if they make that a regular practice, then it makes it, it takes away the sting to employees of getting this notification. It becomes not so much of a big deal or something that's going to cause a lot of upset. It's just the way business is done. You have these kinds of conversations, you get an email, it says it's going to your personnel records. It happens across the board, and it's not so shocking or upsetting.
So the communications between a manager and the employee, those are sort of that's sort of the easy question about going into the personnel record and notifying the employee. I mean, to me, this amendment is a bit of a rabbit hole to the extent that you have a manager, say you have a manager send an email to HR. Employee Smith was absent 2 days this past week or 3 days in the last couple weeks without notice, without notice, or left early or took an extended lunch break, and it's an email from the manager to HR saying, what do I do, giving you notice. First of all, is that and there, in every company and every organization, there are thousands, if not millions, of those kind of communications going on every day about employees. So this, to me, I've never been comfortable that we've resolved the question is that email from the manager to HR, so-and-so was, was absent or came late to work 3 of the last 5 days. Is that a personnel record? Is that within the definition? And then do you have to take that email, put it in the personnel file, and then send the employee notice of that?
My view is that it absolutely is best practice to make that a part of the personnel records, and therefore the employee should be, excuse my voice, provided with a copy. And here's my concern: if those things, those kinds of internal communications about problems with the employee don't go into the personnel records, is that ultimately when the time comes, as we've talked about earlier, where you want to defend a legitimate business action, an adverse action, potentially discharge of this employee, if it's not in the personnel records, and if the employee has not been given an opportunity to be notified that it's in their personnel records and to see it, then it may be down the road that we're going to be precluded from using that information in a court of law. I mean, it's my view that ultimately the case is going to come where a plaintiff's lawyer is going to say this information, this negative information that ultimately negatively impacted my client he or she was never notified of it, never had an opportunity to see it, therefore it's in violation of the statute and is not admissible as a defense against the discrimination claim.
And I don't disagree with your reading of the statute on its terms. The point being, that's almost an impossible burden, I think, for most employers to meet, have every sort of communication like that. And I find in my experience that most employers, yes, performance reviews, personnel action plans, those things all go into the personnel record, but every sort of internal email conversation about an employee that may negatively impact that person's performance, those are sort of the communications that most companies are not gathering, hundreds by the day. I don't disagree with the way the statute's written, but the way it's written, it poses an incredible administrative burden. But I agree with what Tamsin said. I agree with her reading of it and the potential negative impact to the employer down the road in terms of justifying an employment decision.
So you make a great point. This is difficult to manage. It's cumbersome. But what I would recommend is certainly that you keep these requirements in mind, because should there be a problem with an employee, and should that ultimately lead to some kind of disciplinary action and possibly termination, we don't want to see an empty personnel record, or a personnel record, as we talked about earlier, with positive information, and then you give us, a pile this thick of emails from the manager to the HR and from HR to the manager that documented this employee's serious performance issues and never made their way into the personnel record. So certainly, once an employee is headed toward discipline or is becoming a problem, that's the time to remind yourself about this requirement and make sure that that those behind-the-scenes memos are getting into their personnel records. I think that's a reasonable compromise.
Is notice satisfied with just sending the email, or do you need acknowledgement from the employee that they've received it and they know what's going in their file?
In my opinion, as long as you say, as long as you send it to them within your email system, and you say a copy of this is going into your personnel records, then within your email system, you will have the information that you need should you ultimately need it. I don't promote actually asking people to sign off and acknowledge receipt of each and every one of these little notices. I think that's too cumbersome. When it comes to some serious written discipline, you will be having them acknowledge receipt. So very quickly to proceed, I know this is a fascinating topic and all of you have all kinds of interesting questions about it. Right to contest in writing. So if there's a disagreement about information that's contained in the personnel records, or the employee is requesting removal or correction, if you can't mutually agree on a resolution of this issue, the employee always has the right to contest in writing or put their point of view in writing into the personnel record. Now we're going to move on to newly published overtime regulations. I just do want to point out, people will tell you, and this is true, that this personnel records law applies only to employers with 20 or more employees. Bottom line is, it is a big mistake if you have fewer than 20 employees to just blow off the requirements of the statute. This is good practice, it's good guidance, it's the way to conduct your business regardless of the number of employees you have.
Good morning. So I'm Larry Casey. I'm here to talk about the newly published overtime regulations, which is a misnomer because they have yet to be published. They will be published any moment. They could be being published while we speak. I did check this morning before we got here, but nobody in the government was working at the time I checked, unlike here and unlike you guys. But it is a given this is going to happen, and it's all going to cost you some money in some form or another. How many of you here are familiar that there is going to be a change in the overtime rules and regs? Okay, so that's interesting. So a few of you are going to learn some new things here. So first off is, as I said, it's going to happen any day. And there's going to be a significant increase here. So I'm going to go through at the end what the general rules are for overtime, just to remind you, because there's going to be some significance. So first of all, they're going to increase the minimum salary. So you have exempt employees and you have non-exempt. Exempt employees, if they fit the criteria, you do not have to pay overtime if they work more than 40 hours a week. Non-exempt, you have to pay overtime. So in this case, one of the criteria to meet an exempt employee is you have to have a minimum salary. It was $455 a week. It is now going to be, and this is an estimate, the range that has been proposed by the Department of Labor is between $45,000 a year and $50,440 a year. So that would be the minimum salary that you would have to pay somebody to make them an exempt employee. This is roughly in the middle. It translates $47,892 a year. It translates to $921 a week. So for those of you who have exempt employees and are paying a salary to, which hopefully exceeds $455, you are going to have to bump that up to $921, or they're going to be non-exempt employees and you're going to have to pay them overtime if they work more than 40 hours a week. The proposal on overtime regs is what they are going to do to try to help this transition is allow the employer to count non-discretionary bonuses and incentive pay towards some of that 921, but it's limited to 10%. Under the existing rules, you could not count non-discretionary bonuses or incentive pay to meet the 455. But here the Department of Labor, in their proposal, is understanding the significance and saying we're really looking at overall comp. But note, it's non-discretionary bonuses, so that the employee is entitled to them. And it's incentive pay, again, it's got to be non-discretionary. If it's discretionary, it does not count towards meeting that $921 per week, or roughly $47,000, or it could be as much as $50,000 a year. The bonus payments have to be received at least monthly to count. So there's another restriction again. So when you're totaling up what counts to 921, they got to be monthly bonuses. And again, as I mentioned, discretionary bonuses and benefits do not count. Now, part of you may be thinking, why are we making this jump? What you may not realize is under the current salary test at the 455, that gives you a salary of, I think I had it on the slide before, of $23,660 a year. The poverty threshold for a family of 4 currently is $24,008. So the minimum salary to pay somebody and make them an exempt employee is less than the poverty threshold for a family of 4. So the DOL's point of view is there's just people aren't being paid a living wage, and that's part of why we're bumping this up. And what has happened is a lot of companies have said, okay, we'll meet the minimum on the exemption, the salary, make people exempt. We don't have to pay them overtime. And then people are having difficulty making the extra dollars. Back in 1975, and these are statistics that I found. Again, I don't have somebody to credit them to. I should, but in 1975, 62% of salaried workers were paid overtime. Currently, 8%. And that's because of this low minimum salary. One of these, and I'll get into this in a little bit more detail, but one of the exemptions on the highly compensated employee exemption is also being bumped up. Currently, it's $100,000 a year. In order to meet the highly compensated employee exemption, you're now going to have to pay them $122,148 per year. There is not going to be a change as to what exempt, at least right now under the proposal, they're not making a proposal to change what duties have to be performed to meet these exemptions. So when you look at the exemptions, there are certain criteria that you have to meet. One is the salary. You have to pay them a salary. 2 is the amount. And then 3 are the duties. I'm going to get to those in a second. If there are some people that I have come across and have advised as clients, they say, well, I pay this person a salary, they're exempt. That is not the case. That's only one of the criteria to meet. You have to have you have to meet the minimum salary, the base salary amount, and, which I'm going to get to in a second, there are certain criteria you have to meet as far as the duties. They have to be exempt duties within the categories in which you can be exempt. And I'll get to those in one second. So when is all this going to come into play? Well, as I mentioned, at any point in time, they're going to come out and say, here's the new rules. Then the question is, when do they get implemented? It is most likely that this change is going to be treated as a major rule, which requires a 60-day period of time after publication of the rules before they're implemented. So you got at least 60 days. It is possible that you could get as much as 120 days. Unknown yet. The DOL will come out and tell us. But back in 2004, when they made a change to the salary, which was not as significant, it was a more modest change to the base salary, they allowed employers 120 days to implement the change. So there is some time you will possibly have, but you should be thinking now about what to do because the change is going to happen. It may not be 47,000, it may be 50, it may be 40,000, but it's going to be in that range. Yes.
Question on outside salespeople. So lower base salary, higher commission counts, but only 10% of it?
Well, we're going to get to that, but outside salespeople, they do not have a minimum salary. There's no salary requirement. And I'm going to buzz through those just so you can be thinking about what you're going to do, because some of you may be sitting here now thinking you have exempt employees and you don't. And it's only going to get worse. And I will say, once this changes, I'm anticipating there's going to be a lot more litigation and a lot more pushback from lawyers and employees about you're not meeting the requirements, you're not paying me enough, I should be getting overtime. It's going to stir up the pot. So some of the things for you guys to be thinking about, because this change is going to happen, is what positions are going to be impacted? Who are my employees now that I consider exempt, are earning that $455 that I now have to give more than 100% increase in salary to? What do I do about that? Do I convert those employees to non-exempt and start paying them overtime? And you can run the numbers. It may be cheaper for you to do that. You may have employees that are exempt who are working 60 hours a week. You take that extra 20 hours and multiply it by overtime, which is time and a half, and you can figure out the numbers where it may make sense. You have to also think about, if I'm raising salaries for these individuals, what's the impact on the other employees who aren't impacted, employees who are clearly exempt and at a wage. Now all of a sudden these employees who you have at the base exempt level are being driven up closer to employees who are much more clearly exempt. Now you have some wage maybe inequities or perceptions from employees. So you have to think about that. You also have to think about, if I now have employees that I'm putting on overtime and I'm going to not have them exempt anymore, they are now going to be non-exempt. Now we have to track their hours. And tracking their hours is training those employees that they have to be tracked, where you're clocking in or they log in on the computer, however that is, and you have to maintain those records. So, and I believe it's for a 3-year period. So any employees who are hourly, you have to track their records. When are they in? When are they out? If there's overtime, you have to track them and keep them. There's going to be a lot of companies out there that aren't used to that because they have a lot of employees who they have at this exempt level. And if you now make the choice that they're going to be non-exempt, you now have this additional administrative burden. You got to notify your employees of the changes. It's funny, my daughter was had started a job about a year ago, so she says, I'm up for a raise. And so she was getting all confident and jazzed up to go in and talk about the raise. And she kept trying to get the meeting, and the manager would postpone it. Something came up, and she was getting a little bit anxious about it and some anxiety. And then she learned, I don't know how she picked it up, but she saw that this change was going to happen. And she sent me an email that said, well, maybe at least I'll get a raise through this. Because she's an exempt employee. I'm not sure she fits, but they're paying her as if she was, but she's working, clearly, I'd say 60 hours a week. So she's going to get a raise one way or the other, either through overtime or through this bump. Hopefully it's this bump. So let's talk a little bit about the exemptions, because people tend to focus just on the salary. So one of the exemptions is an executive employee. If you're an executive employee, you have to have that base salary, which is now going to be $921. But the primary duty has to be management of the enterprise or a recognized department of the business. Second of all, you have to direct the work of 2 or more individuals. So if you don't supervise 2 or more individuals, you don't meet the executive employee test. And you have to have the authority to hire or fire, or have your decision or your vote has significant influence. If you have all of those, you meet the exemption for an executive. You don't have to pay that person overtime. The next one is probably the one where most people tend to fit their employees, which is the administrative employee test. Again, you have the base salary requirement, which will be, I'm telling you, roughly $921 a week. That person's primary duty has to be office or non-manual work related to management of general business operations. So think about that. They have to be management of general business operations of the employer or the employer's customers. So again, it's not just somebody who doesn't have any responsibility and duties within the operations just because you're paying them a salary. If it's a receptionist you're paying a salary, I don't think they're involved in the operations significantly enough, because the third part is the primary duty includes exercise of discretion and independent judgment with respect to matters of significance. So even executive assistants might not meet that criteria. So when you're thinking about, when we're making this change, do I bump this person up to 921 and do I now make this person exempt? You still have to analyze this. Do they do the office non-manual work, management of general business operations, and are they exercising discretion and independent judgment with respect to matters of significance? And that's matters of significance to the business. The third type of employee who can be exempt is a professional employee. Again, same base salary level. Their primary duty concerns work requiring knowledge of an advanced type, generally intellectual in character, that includes the exercise of discretion and judgment, and is an area where you customarily receive training and significant education in a prolonged course of specialized instruction. Scientists, engineers, lawyers, that type of thing. Again, their primary duty has to involve that type of work that requires that type of knowledge. On the creative side, if you don't have that, the primary duty, and again, you can fit professional, is where your duty requires performance of work that requires invention, imagination, originality, or talent in a recognized field of artistic or creative endeavor. So that's for people who are doing marketing, who are involved in, I would say, paintings, artists, that type of thing. The next category is computer. And this is one that a lot of people, I'm sure, use and understand. There's going to be a difference, and I don't know what they're going to do with the hourly rate. But currently, for a computer employee, they have to have the base salary of $4.55 or an hourly rate of $27.63. Those are clearly going to go up, and I assume they're going to keep, it appears they're going to keep, you can do the salary or you can do the hourly. To meet the computer exemption, it has to be a computer systems analyst, computer programmer, software engineer, those types of individuals. But they only qualify if their primary duty consists of certain types of computer work. For instance, application of systems analysis, where you're consulting with users to determine what the hardware should be, what the software system should be, what its function should be, that type of thing. It could include primary duties involving design, development, documentation of computer systems or programs, or concerning machine operating systems, again, to meet this computer exemption. Or you can have a combination of the above. The next category is the outside sales. So there is no minimum salary. Certainly they're going to be paid on commission basis, bonuses. Again, the bonus needs to fit, generally as a non-discretionary. But the primary duty for a salesperson has to be you're making sales or obtaining orders or contracts, or it could be for the use of your facilities. Again, you're getting contracts for people to use your facilities. And the company's paying a consideration for that. Obviously, the customer's paying. The employee needs to be customarily and regularly engaged away from the place of business in doing this. That's what makes them outside sales. And if you are involved in that type of work, then they qualify for being exempt. Last is the highly compensated workers. Again, right now, the compensation has to be a total of $100,000. It's going to be $122,000 or around that range very shortly. That's what's been proposed. The employee has to earn a total amount of annual comp that equals that. It can include bonuses. It can include, again, non-discretionary, and it can include commissions. The employee's primary duty, again, has to be office or non-manual work, and they have to be customarily or regularly performing one of the exempt duties that I just recited above. They either have to do the exempt duties of an executive, the exempt duties of an administrative person, or the exempt duties of a professional person. So that's what's coming down the pike. For Zola, yes, Orlando.
Well, what about inside sales?
Inside sales are not exempt. If they're not outside, primarily outside the office, doing their sales, they're not going to meet the inside sales exemption. Could you fit them in one of your in the administrative category or the executive category if they're managing people? Possibly. But if you're relying on sales and they're inside only, that's not going to work. Yes.
So I think you and I are on a similar ballpark here. So we're design, my kitchen designer is designing the kitchen, so they would qualify for professional status because it's, well, or more of a.
If they're an engineer and designing the kitchen, then maybe. But if you've got an inside salesperson who's designing kitchens, if they're going out and selling either to Home Depot, we want to do kitchen designs, or we're selling to any of the other places that are out there marketing to individuals who are going to be redoing their kitchens, and you're trying to sell your products and design services so they provide them to their customers, and he's outside the office selling to that, yes. If he's going door to door to residential homes and saying, I can design your kitchen, yes. But if he's inside sales,
But that's not, I know, Sean, that's not what your people are doing, and they're not really in this, I mean, they sell, but they're not outside sales, they're not selling to distributors. Your customers come in, which are residential homeowners for the most
The
part.
contractors.
Contractors.
So if you renovate your house, I'm selling to your contractor, who puts it in for you. So
Okay.
I'm not doing outside sales, he's bringing that customer to me.
so the contractor is bringing the customer to you, and then that person is working on the design.
So my designers will design it, formulate it, and based on the space, so they may go out and measure your space, but they're not really doing any outside sales.
So then I would say they're not really doing, they're doing non-manual work. It's related to the general management, the general business operations, which is your general business operations. I'm selling kitchen designs. I'm going to go out and formulate the designs and have them implemented. The contractor puts it in, you don't put it in, so you're doing the design work. And or you fit within the professional. I mean, that's where I would be focusing your individuals and clicking off those requirements and making sure they're met. Watch out for this. It's going to be around the pike. We certainly will send out an alert. All of you are here because you got the email for here, so I'm sure you will get the alert when it happens, and we'll be happy to keep you informed and happy to talk to you about implementing changes that you need to. So every year, they're intending to increase the salary automatically, and they're going to do it based on Bureau of Labor Statistics or the CPIU. So this will change year in and year out.
So very briefly, this is a common problem. People misidentify their workers as independent contractors rather than employees. In Massachusetts, we have a very strict statute, and in order to classify someone properly as an independent contractor, in other words, you do not pay them through payroll, you do not take withholdings, they're not entitled to the various benefits of employment. To make them a proper independent contractor, we use this three-prong test, and you have to meet all three of the prongs, which are: number one, the worker is completely free from control and direction of you as an employer. Number two, what they do is outside the usual course of your business. We're a law firm. We cannot have an independent contractor lawyer. We can have an independent contractor come in and install shelving in our closets. Number three, this person has an independent trade, occupation, profession, or business, meaning that they also do the work that they're doing for you for other entities, for other people and companies. It's a very strict test. Many times this is a problem, and you can run afoul of the rules and get into trouble on many levels, with the IRS, with the DOR, with unemployment, with workers' comp, etc. So it's something to really be taken seriously and make sure that those three prongs are all being met in order to treat someone as an independent contractor. So we need to wrap up now. We've gone over, but all three of us will be here, and we're happy to take questions following the conclusion of our presentation.
I got two things to wrap up.
Okay.
60 seconds. One, the word is transgender. Okay, if you're reading the news, you'll probably likely aware there's a lot of news, a lot of action in the area of what are the legal rights of transgender, the transgender people. Laws in North Carolina. It's in the news all the time. So two things about that. The federal EEOC, Equal Employment Opportunity Commission, which is charged with enforcing federal, not state law, but Title VII, has issued a fact sheet taking the position that discrimination against the transgender community equals sex discrimination. So you have this whole issue of bathroom access. The EEOC, as a matter of federal law, has told the country they're treating that discrimination as a violation of Title VII on the federal statute. In Massachusetts, there's a bill being debated. There are bills pending in both the House and State Senate. The State Senate is debating its version of the bill today. The House bill will be debated. We'll see what will come of that. The governor has sort of been a little coy about whether, what he'll do with it, but we don't know what the bill's going to look at. My understanding of only a quick read of it is that it relates more to public accommodations than employment discrimination, but we'll have to see what comes out of each the Senate and the House version, and then if there are differences, a conference committee, and then what the governor will do. But we'll certainly provide an alert on that.
But under the Massachusetts Fair Employment Practices Act, we already have an anti-discrimination amendment so that we cannot discriminate in employment based on someone's gender identity or expression.
Okay, so that was it. We'd like to thank Joanne Thorpe, our Director of Marketing, for once again pulling this all together and doing all the hard work on this. So thank you, Joanne. Thank you all for coming. We'll be around for a little bit if there's any other questions anyone wants to throw at us. Okay? Thanks for coming, everybody.